Can state governments give preferential treatment to certain subcastes within the scheduled castes? A 7-judge bench of the Supreme Court has ruled that subclassification of scheduled castes is in fact permissible to grant separate quotas for more backwards within the SC categories. What does this mean and why did the Supreme Court have to look into this issue? I, Apoorva Mandhani, will tell you in this video. Now, the genesis of this issue traces back to the Punjab legislature enacting the Punjab Scheduled Castes and Backward Classes Reservation in Services Act 2006. As the name suggests, the law was to provide for reservation in services for the members of the scheduled caste and backward classes. It said that 25% reservation shall be made for members of the scheduled castes and 12% for the backward classes while filling up vacancies by direct recruitment in services. However, and this is what led to this verdict, the new Supreme Court verdict, the Punjab law said that out of the seats reserved for scheduled castes, 50% would be offered to Balmikis and Mazhabi Sikhs, subject to their availability by providing them preference from amongst the scheduled caste candidates. A 2-judge bench of the Punjab and Haryana High Court had struck down the provisions as unconstitutional on 29th March 2010. It had done so relying on a 2004 judgment in the E.V. Chennaiya case, and I'll tell you more about this judgment in this 2004 judgment in just a bit. But similarly, Tamil Nadu had also made a law in 2009 which said that 16% of the seats reserved for scheduled castes in educational institutions shall be offered to the caste of Arundhatiyars if available, having regard to the social and educational backwardness of the community. This was also challenged before the Supreme Court, saying that it violates again the 2004 judgment in the E.V. Chennaiya case. Now let's come to this 2004 judgment. In this 2004 verdict, a 5-judge Supreme Court bench had declared Andhra law unconstitutional. This Andhra law divided the scheduled castes into 4 categories and gave them different percentages of reservation with 15% as the total limit. The court had then held that the state government cannot do this because the presidential list, that is the presidential SC and ST list, is one homogeneous class which the state government cannot tinker with. However, in 2020, while considering the Punjab law that I earlier told you about, a 5-judge bench disagreed with the 2004 judgment. In doing so, a bench comprising Justices Arun Mishra, Indira Banerjee, Vineet Saran, M.R. Shah and Anirudh Bose asserted that, and I quote, there are unequals within the list of scheduled castes, scheduled tribes and socially and educationally backward classes, unquote. So this is how the issue reached back to the Supreme Court after all these years, and the 5-judge bench referred the issue to a larger bench. Now, before telling you about the judgment, about Thursday's judgment, let me tell you a bit about the constitutional provisions involved in this. Basically, Article 341 of the Constitution empowers the President to notify the castes, races or tribes that will be considered as scheduled castes in a state or a union territory. For states, the President is also required to consult with the Governor before issuing such a notification. Clause 2 of Article 341 also says that the Parliament can make a law to include or exclude any caste or tribe from this list. Similar provisions have been made for the scheduled tribes under Article 342 and for socially and educationally backward classes under Article 342A. You can see these articles on your screen, of course. Now, the state legislatures can then, under Articles 15 subclause 4 and Article 16(4), provide for reservation for these notified SCs and STs. Articles 15(4) and 16(4) allow the government to make special provisions for reservation and admissions in higher academic places and appointments for those communities which are socially, educationally backwards classes or from scheduled castes or scheduled tribes and, in the opinion of the state, are not adequately represented in the services under the state. Now, the Supreme Court's 7-judge bench ruling on Thursday in a 6:1 majority ruling held that scheduled castes can in fact be subclassified for the purposes of reservation. This 7-judge bench had Chief Justice of India D.Y. Chandrachud with Justices B.R. Gavai, Vikram Nath, Bela Trivedi, Pankaj Mithil, Manoj Mishra and Satish Chandra Sharma. Justice Bela Trivedi out of this bench dissented from the majority and ruled that such subclassification is not permissible. CJI Chandrachud observed that historical and empirical evidence shows that scheduled castes are a socially heterogeneous class, and so the state under Articles 15(4) and 16(4) can further classify the scheduled castes. One of the questions before the court was also whether subclassification or preferential treatment within the SCs and STs amounts to excluding them from the presidential lists. The question was raised because Articles 341, 342 and 342A only allows the parliament to make a law for excluding or including any castes, tribes, races, tribal communities or groups from these presidential lists. So, the court opined that subclassification within the scheduled caste does not in fact violate Article 341 because the castes are not per se included in or excluded from the list. It asserted that subclassification would violate the provision only when either preference or exclusive benefit is provided to certain castes or groups of the scheduled caste over all the seats reserved for the class. So, in other words, it would violate Article 341 only if 100% seats available for scheduled castes are reserved in favor of a subclass, excluding all the other subclasses. The court also opined that Article 14, which provides for equality before law, permits subclassification of a class which is not similarly situated. Now, overruling the 2004 E.V. Chennaiya judgment, the court has said that the objective of any form of affirmative action, including subclassification, is to provide substantial equality of opportunity for the backward classes. So, it said that the state can subclassify based on inadequate representation of certain castes. To do this, the state must collect data on the inadequacy of representation in the services of the state because it is used as an indicator of backwardness. This is what the court said. Pertinently, there were several opinions that different judges wrote for agreeing with the majority verdict, but Justice Gavai in a separate opinion also said that the state must evolve a policy for identifying the creamy layer even from the scheduled caste and scheduled tribes so as to exclude them from the benefit of affirmative action or reservation. He asserted that only this and this alone can achieve real equality as enshrined under the Constitution. Justice Vikram Nath also concurred with this view that the creamy layer principle as applicable to OBCs also applies to SCs and STs. Justice Satish Chandra Sharma also agreed with Justice Gavai, and a similar view was taken by Justice Pankaj Mittal, who said that reservation should be limited only for the first generation or one generation, and if any generation in the family has taken advantage of the reservation and have achieved higher status, the benefit of reservation would not be logically available to the second generation. So, that is what this 7-judge bench has ruled on Thursday in a very, very important ruling. That is all I have for you today. This is Apoorva Mandhani for The Print. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.